Hello, everyone. Welcome to the Angels and Awakening podcast. My name's Julie Jancis, and I'm your host. Today, we are talking about wills and trust. Why? Because in the business that I work in every day, there are so many people who deal with this, and a lot of times what I see is that it's not done in a way that is, shall I say, emotionally healthy, and perhaps even we could, if we knew more, do things in a way that just set up the people that we're leaving behind in a way that benefits them to the greatest degree. So when my dad passed away, and I know I've talked about this before a little bit, what you don't know is that he left behind two sons that were underage. And he had 3 marriages. In his second marriage, he had his sons, and in the divorce, there was a legal document stating that in the case of my father's passing, those boys would get $200,000 to use for their college, to use to get them grown until they were 18. Well, because my dad was a federal employee, and I don't know if that's really the true reason, that's just what I was told. What happened was his third wife did not share the will that he had left with anyone. He didn't share his will with anyone else, and so his third wife, we don't know if she took it and chucked it in the fire. We don't know what happened, but we do know because she told us of her own words that there were letters for my sister, myself, my brothers, and those letters were never received by any of us. There was supposed to be mementos that were given to us. That wasn't received. And it has been, they have spent over $10,000. It might be 15, it might be 20, fighting this. I have not fought any of it myself, but you can spend a lot of money in these situations. It's very hurtful. It's very painful. There are other situations that I've dealt with my clients where they come in and they'll say, you know, my sister took everything. She went into the house and she took all of the possessions out that I had wanted. There are other situations where money is just not distributed the way that they thought the parents should have distributed it. So there's a lot of hurt. There can be a lot of pain in these different situations. And I wanted to bring in my personal lawyer. I'm not getting any kickbacks from this. I just wanted to bring her on because she is so trustworthy. We had gone through a different lawyer before to do our will and trust, and when we brought it to her for updates, she said, there had been so many things done wrong. So welcome Liz Jerkasek. She is a lawyer in the state of Illinois, and I highly, highly recommend her. Liz, can you tell us a little bit more about yourself?
Sure, Julie, and thank you for asking me to join you today. I'm a sole practitioner in Illinois. My office is in Chicago. I've been an attorney for 28 years, and my area of practice tends to be in small business owners, and as well as I also do estate planning for all kinds of different people from all levels of our society. So that's who I am, and that's what I do.
That's wonderful, Liz. So can you talk to our listeners about what is the difference between a will and a trust, and what do people want to have set up and why?
Well, Julie, the difference between a will and a trust. I don't want to go through, and I'm sure no one wants to hear about, an entire semester of estate planning in law school, but there are 2 different documents. However, they can be the same. So this can be kind of complicated, but very simply, I look at a will as a way to give away the stuff you can touch. Your collections, your clothing, your car, that kind of thing. A trust generally covers a much broader group of assets and items. So a trust can be used to help an individual who's, say, going through a physical situation or getting older and they need help and they have a person appointed to help pay their bills and their expenses, and then after death, those all of those assets are distributed. Going back to a will is just when you pass away, where does your stuff go? Okay, so the spillover is that a trust really can last a lot longer. Number two, a trust also is a little more, I would call it flexible, and really flexible isn't the right word, but let's use that one. So a trust can be used to cover situations where if you have a family member who has some sort of illness, or you have a child who has some sort of condition, you can provide for their care and comfort for a very long period of time. Also, a trust generally can be, and again, there's rules on this, multi-generational. So you can cover your grandchildren and possibly even a fourth generation. Now, a will can do some of this, so I don't want to get confused, but generally a will just covers the here and now, and upon the death of the person who made the will, that's when all the stuff goes out. Does this make sense?
It does. Here's the problem that I see that people just don't understand. With a will, it's not uncommon for me to have people coming into my office and they say, you know, my mom or my dad passed away 5 years ago, or so-and-so passed away 5 years ago, 6 years ago, and the will is still not wrapped up. Because when the will has different people going at it for different things, what happens is it goes to probate. Is that correct? And it can get stuck in probate for 4, 5, 6 years easy.
Correct. And that's really one of the, what I would call, best reasons to invest in having a trust. Because what we do with a will is we provide for, say, custody of children. We provide for your final wishes. This is all in the will. And we provide for the distribution of what I just said, your tangible assets. And then, what a good trust should say, and then all other assets I give, devise, and bequeath into, the Liz Jerkasek Living Trust Agreement dated, October 1st, 2019. And then that means all of the other assets that aren't like touchable ones go by way of the trust. Now the trust, you don't probate a trust. A trust is just it's really a business agreement that says, here's going to be the people that are my caretakers, and this is what I want done with my stuff. Absolutely removes all the assets that come under it out of probate. So you're right, Julie, with a trust, again, nothing is nothing is guaranteed in this life, but generally a trust is that umbrella of protection to save assets and ensure, hopefully, that they go to the people who are supposed to receive them.
Yeah, that makes total sense. The other thing that I don't think that people know is just how much money it can cost to go through probate. So if you have a will, let's say you have children from a previous marriage and you want to ensure that those kids are going to get what they are owed by the previous spouse. If you have a trust, or that other spouse has a trust, then you're not paying thousands upon thousands upon thousands of dollars during probate. So with a will, think will equals probate equals lawyer for 5, 6 years equals, tens upon tens of thousands of dollars, right? And a will might cost you less up front, and a trust might cost a little bit more, but in the long run, it seems like you would be saving so much money to have a trust because it's open and closed, within like a month?
Yeah, and so that can be true, but of course there can be shenanigans in a trust, right? But in a will, really what you're doing is you're just saying you're going to pay my final expenses. Here are going to be my successor executors of my estate, the people who are going to manage everything. usually one person at a time. Now, you have to remember, this area of law it's found money. So you give somebody, and it doesn't matter whether it's $10,000, $20,000, or $20 million. To some people, it's found money. So I think the question that you're asking, and I sort of agree with you, is that where will the person who is doing the estate planning have sort of the most comfort that their wishes will be followed? Well, in a will, it goes to probate, so you've got a judge on your side trying to ensure that the assets are distributed and the debts are paid. In a trust, you have just the successor trustees who are managing your estate after death. So I don't want to give you the impression that it's foolproof. It just seems to me, and I do agree with you, that with a trust, you have an added level of protection because a trustee has to give reports. They have to give at least annual reports to the person who they're managing the trust for, and then upon that person's death, to the beneficiaries. Mm-hmm. And everything is supposed to match up and add up. Now, gotcha. I think, when you add it up, I agree with you that for some people who can afford it, a trust will give an added level of protection. Now, in the instance of children from prior marriages, it's really hard to say what is the best strategy. Should it be life insurance? Maybe. Should it be a separate asset? Because to make this whole discussion get more complicated, there's something called will substitute. So let's say that, in the case of, say, your father, he was, adamant about protecting everyone. An option for him would have been to set up an IRA for himself and then provide that, in the contract that upon his death, this IRA, whether it's at Fidelity or, Charles Schwab, that asset goes to, and then his children. So that asset takes all that money. It does not go by way of the will. It does not go by way of a trust. The money goes, boom, next day, with a presentment of a will and a death certificate to the people who are named on that account. So, but you have to talk to a lawyer. You have to. This is a conversation you want to have, and you want to have it on some level, not really blatant, but on some level with the people with whom you're leaving behind, a spouse, children from a prior marriage if they're old enough, so that everyone kind of understands what the plan is.
Yeah, I totally get that. And I think one of the hardest things that I see with the couples that I work with is that the primary reason that a will or trust does not get done with couples who have children is a lot of times they can't end up deciding on, there's a lot of tension in deciding on who the children would go with. Do you see that?
This is, the number is in the double digits, and I don't have the exact number, but it is greater than 30%. That's the last time I looked at the statistics. And this is an issue, right? So people don't necessarily want the husband's family to have, we'll call it sole custody of the children, or the wife's family to have sole custody of the children. To which I say, again, talk to a lawyer. There could be a way, and what I usually recommend is people take and divide up the job. You can divide up the job of guardian of the children into two jobs. The first job should be, guardian of the money, right? And the second one is the guardian of the children, physical custody. So in that way, the two families are still involved. And by dividing up the job, you also, I would think, ensure that there's, again, this is a fiduciary relationship for both families to have contact with each other and provide for the care and provide for the financial reporting so that the children are cared for. So there are, again, solutions to this, and it is very tragic when people can't sit down and say, okay, let's divide the jobs up.
Right. Yeah. Well, and what I see in my job too, in working with spirit, is just that, you know, we like to think about it in terms of black and white, but there's really two things that we find opposing that are true at the same time for spirit, which is a lot of times we like to think on earth that everything is divinely timed and that everything happens for a reason. And there's a lot of cases where that's true. However, we do have free will here on earth, and there are accidents. There are a lot of things where your soul, there's a plan for your soul here, and even though it's not something that we want to go through here in life, it's something that helps our soul to learn and grow. But because we have free will, there are accidents here that happen, and we just want our loved ones to be set up for the best case scenario. And I've seen couples drag their feet. I know Blake and I did for a while, but for over 2-3 years, and not having something set up because they just couldn't figure out who they wanted the person to be. And it gives me so much anxiety because I just want every child to be set up, right?
Of course. And again, this is probably, for people under 50, this is probably the number one reason they can't bring themselves to approach an estate plan, because they don't want the fight, they don't want the anxiety, and quite frankly, I think that people think, well, if we broach this topic, we're inviting this to our doorstep, and that is the farthest thing from the truth. And as I said, I've been doing this 28 years. It has never happened where somebody has come to me and say, you know, I want to do a will, and then a year later they perish. You know, it really, right? So, I mean, I unfortunately been at sad times where I've had to go to hospitals and help people, you know, sign final documents. But I'm talking about where people are just like making an initial plan. So this is something that I think that you have to think about. Really, I think people who have experienced great loss can understand what happens when this is not done. But if you have never experienced a great loss, it's kind of hard to wrap around how you can deal with the fact of, you know, this person in your life passing and leaving you with, you know, 5 banker boxes to sort through. If you're lucky, they're in banker boxes to sort through and understand while you're grieving and you're just trying to breathe to get through the next hour. Right? And that's exactly what you know, I've experienced, and people that I care about have experienced. You can barely breathe, and it takes months to get to beyond that. Meanwhile, you know, things are happening very rapidly out in the real world, with bills having to be paid and assets having to be managed. So you really have to take a moment and think about the people you care about and go, what is the most realistic solution here if something happens to me. The other thing I want to say is that people think that there's going to be one will throughout their entire life, or there's going to be one trust. Really, this is just not, I don't think it's possible, because unless you're, you know, one of those lucky people who say as a woman you can wear a size 8 at 18 and you're still wearing a size 8 at 70, you know, that's wonderful. But most women aren't wearing a size 8 at size 70, you know, really, so things change. So the will that you create at, say, 30 or 35 can be changed with a codicil. A trust that you create can be changed and modified with a trust agreement. And you shouldn't be afraid to switch things up and change them, and to change people as different people come into your life, or people who you have a better comfort level with. So you don't feel stuck, like, oh, these are the people I'm picking, and, you know, what do I do? What do I do? What do I do? Well, you can make a change, and it's not expensive, and it's really quite easy to do.
Well, let's talk about that, because Blake and I really overpaid, and we didn't know that we overpaid when we first did our will and trust, and I think we paid over $3,000 for it. what is typical to pay for a will and trust to be done?
Okay, so let's talk about what I would call like the average person, say in their mid-30s, with maybe a couple IRAs, accounts, maybe some benefits through work, a house, right? A couple, maybe a bank account or just some like rainy day fund kind of things, and then regular assets. Okay? So this, I think, describes the most people we could put into this group.
Sure.
The average, and you have a couple, right? Now, this is my thought process on this. If I'm doing a trust for a couple, yes, I'm doing like two different trusts, but really it's one trust.
Right.
So, I'm just basically, find and replace names to change the gender and change the names of the people that I'm doing the trust for. I'm doing it one time. So I think that you generally, for this kind of estate plan, you would be looking basically to do a will and a trust and all the powers of attorney.
Right.
Because we haven't spoke about those, because those are important too, a healthcare power of attorney. You would be looking at, I would say, for a couple, probably about $2,000 to $2,500 on average.
Yeah.
That's that, and that, like I said, it includes the wills and it includes a healthcare power of attorney.
Right. So tell us what that power of attorney is, because some people don't know. But this comes up all the time in my sessions too, where something happens to somebody and the power of attorney has to step in. Some people don't even know what that is, though.
Well, in Illinois, there's two kinds of powers of attorney. There's a power of attorney for property, and there's a power of attorney for health care. Now, the healthcare power of attorney is just what it sounds like. It's for those, two great points, I guess. When you have a serious situation, whether it's an operation or an illness, and you, the individual, are not able to make decisions regarding what treatment should come next. So you appoint somebody to be your agent, and if you're, able to appoint more than one person to act, consecutively, not together, so that you have a backup plan of people who will stand by you. And let's be honest, I would say be your advocate, and your ugly advocate. You want somebody who is strong and who is clear in their mind what your wishes are. So, they can get access to your health care records. They can check you out of whatever facility you're at if they're unhappy. And you want somebody who is strong and really, as I say, kind of a loudmouth in some respects. That's the healthcare power of attorney. And when that is signed, that is generally good until the very end of your life. Now, it is not, and I'm going to be clear on this, a healthcare power of attorney is not an end-of-life decision. Those documents are very unique in Illinois, and right now, as I understand it, only a doctor can give you the form and agree to, like, this is the point where, I agree, you should not be resuscitated. Okay, that's the one main one. The other one that exists in Illinois is called a property power of attorney. Now, in the instance that you may not need a trust or you want, extra coverage with your family members, you can appoint somebody while you're alive. This document, the property power of attorney is only good during the person's life to make financial decisions, to go to the bank for you, to withdraw money, to deposit money, to deal with your Social Security, to deal with your Medicare, to deal with your IRAs, to deal with all of your accounts, to sell your property, to buy property for you, to give gifts. That's a durable power of attorney for property. And that is a very powerful document, because this is the keys to the kingdom, where you are saying, you can step in my shoes and make any decision, and I trust you to make the proper decision. That's another document that could be very important. Now, let's say that, you're not in a position to do a trust. Okay. And you have a will. Okay. And then we would do the powers of attorney for you. Now, the next question is, do you own real estate? Because really, this is the next question that I think if I were to give, a test in estate planning, this drives everything. What happens to the house? You cannot, under Illinois law, transfer a home by way of a will. The only way to transfer a property, real property, in Illinois is by way of a deed. So,
but isn't the will in the deed, or the deed in the will?
No,
okay.
That's not true.
This.
So, right. So, when you have a couple, typically you own the real estate, as joint tenants, or say there's different ways to hold property, but let's just say jointly. Now, frequently we get a situation where one of the parties has passed away. So now we have a question in our head. What happens when that survivor is going to pass? And so this is, you think, well, I've got a will and I've got powers of attorney. I'm now, air quotes, safe. Not necessarily true with the real estate, because this can push you into probate. Although I will tell you that there's always change afoot to change this stack in Illinois to make it a little simpler, because this is what tips many, 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 many families into having to go take an estate through probate, is because there's a deed and the last person on the will, as they were jointly, has now passed. The solution to this is to circle back to the first part of our conversation and have a trust. Because by putting the real estate into a trust, you then ensure that the property can be sold, the proceeds can be divided among the people in the trust. You cannot do that in a will. Only
I have seen this before, and I've seen it a lot of times where, let's say there's 2, 3+ siblings, and the house ends up going to probate, and one of the siblings, it never fails, will drag their feet, male or female, and they are so sentimental, and they do not want to sell this house. They're not ready to sell the house. There's too many emotions associated with this house that they grew up in, and now you're stuck paying for the house because one person won't sign over. Have you seen this before? What's going on there? And it seems like in those scenarios, I've talked to a lot of families where they're losing a lot of money because this house is draining it.
Well, and that can happen, and it can happen when there's a trust as well, right? Because really the trust provides that upon the death of the last of the spouses, the home is to be sold, and the proceeds divided among the children, the siblings. Well, that situation is a very hard situation because, quite honestly, this person has to, whether it's through therapy or through some family discussion, understand that at the end of the day, this is property, and it has to be liquidated. So again, a court can be involved just in that kind of dispute. And quite frankly, and I mean, I bet all your listeners, can point to experiences they have had where there's always that one family member who, boy, their fingers are very slippery, and you don't know, are they being honest? Are they being truthful? And that's a whole other situation that can arise. Is there a proper accounting? And, you have to be very, very careful in staying involved when an estate is being handled, to know, am I getting fair and truthful documents regarding how this estate is being managed?
Is it better in those situations for everyone to just have their own lawyer, even if everybody is friendly and lovey with one another? It just seems like it's a really hard situation.
Well, let's go to the hypothetical where we were talking about, where there were, say, a couple siblings who are, well, it's time to sell this house, and then the one sibling has got a holdout. I think that sibling is going to have to get his or her own attorney, because in that situation, the attorney hopefully will be ethical enough to say, you're going to lose. There's no way to hold on to this house. In fact, if you continue blocking this, there could be repercussions for you for having to pay back your siblings for, wasting. It's called wasting the asset. So, and I think an attorney also has an obligation when they have a group of attorneys, a group of clients, and there is conflict, to tell that one client they need to seek other counsel. A lot of times, I'm sure if people have met attorneys, they like to think that they can solve all problems, but really some problems are just not solvable, and you have to step up and do what's best and tell the client, this person is going to have a separate attorney because it's just not going to move forward. I'm always of the mindset that, 3 attorneys are worse than 1 attorney handling a matter. It would be nice if everyone could work well together, and in many cases people do.
That's good.
But sure as heaven and earth, there's going to be a situation where somebody is just not going to be happy no matter what. Mm-hmm. It's very tragic.
What about those situations? Because the other big thing that comes up all the time for me is somebody will come in, and when I do my readings list, people are on a massage table, and I'm going through their chakra and their auric field, and I'm doing energy healing while I'm bringing through their messages. Sometimes you get to the heart chakra, and there's so much pain because, let's say, 2 siblings really wanted mom's earrings or mom's watch, and one sibling just went into the house and took it. How does that work? How do you go about that? And then you get into a hard situation with your sibling of, well, what do you even say, to them? I wanted that, I don't know how the correct way to go about it is.
Well,
and let me just say, too, there's so much grief at that time, too, right? I mean, one sibling might be completely respectful and let's not touch anything, let's just, their mind is in grief, and somebody just goes in and starts clearing everything out.
Well, this happens certainly, right? Because that's usually a dynamic that occurs in most families. I bet, again, this is a very common situation. The appropriate conduct is to go through and do what's called an accounting. And even if you think, oh, this is all just a bunch of 50-year-old garbage, really it is a moment where people should sit down together and go through everything and figure out, okay, this is the jewelry, this is the artwork, this is the whatever, and then apportion it. Now, if you have a will, really the will should say, my wedding ring to this, my grandmother's earrings to that person, my baseball card collection, Yankees to somebody, Chicago Cubs to somebody. You can be that detailed in your will. Now, what happens when somebody comes in and just says, okay, I'm going to take all the good stuff and leave the 50-year-old garbage for the rest of you 3 to divide up? Well, that's a big problem. And again, sadly, I mean, you end up back in probate, right? Because this is a legitimate fight and could land that person in serious trouble for confiscating things that are not properly given to him or her. It's a huge problem. Yes.
Yeah, and I see that most people don't end up litigating it. They end up bringing it into their heart chakra, and they're just so hurt and so devastated that, they wanted a relic to remember mom or dad by, and now they don't have it. So that's really interesting. What other situations do you see come up a lot that are just common throughout all the people that you work with? What are some good insights that we could give our listeners?
Well, really what I think, I think the biggest issue is to go back to the situation of what do I do with the house. I will tell you, Illinois has sort of what I would call a new device called a transfer on death instrument. And so the acronym is TODI. So again, going in a situation where you have all the things that you can touch, you can give away, and you have a house, you can create the equivalent of a deed now and say, upon my death, I want my home sold and the proceeds divided among. And there's a attorneys know how to prepare this document, and you record it. And then this is now a new and interesting thing because it will save people, a fair amount of money if they're not going to have, the $1,600 as an individual to do a trust, or the $2,400 as a couple to do a trust. So this is one way to get around it. There's also something called a land trust in Illinois. Now, this is completely unique to Illinois. And you can set up a trust for just the real estate. And it usually costs about $200 to set up, and then $100 forever after. And you're going to say to yourself, if you're sharp, but hey, 16 years, we're already at the point of a trust. Well, yes, you are, but, it's $100 at a time. And for some people, that's really what they can do. And if that's all that you can do, that's all you can do. And that brings me to a point. I think you have to say to yourself, this is, a budget that I can manage, and I'm going to go sit down with an attorney, and you're going to hopefully have a strong relationship pretty quickly with that attorney, where that attorney can look you in the eye, be confident without being overbearing, and speak in plain English. Now, if this is not your experience with your attorney, well, good luck. In Illinois, there's 75,000 attorneys. You can find another one. So you should not feel that you have to be stuck with somebody because your brother, your nephew, your hairdresser, your parents use this attorney all of their lives. Find one that you can work with and be clear on your budget and come to, I think, a closure for you on what you can do to create a plan that works for you.
Yeah. Well, it was interesting, too, was when Blake and I were talking to you, one of the things that you didn't like that our past lawyer did was she took a copy and kept it on file. Why shouldn't you have your lawyer keep a copy of your will and trust on file?
My reasoning for this is because, number one, you could change your will or you could change your trust with a different lawyer. Now you have kind of chaos because the original attorney has the originals. My second problem with this is really from the attorney's position. This is just a nightmare waiting to happen. Again, attorneys do not live into infinity beyond. When that attorney passes away, let's say, they have a box at a bank, what's going to happen? Who's going to go through 50 years of wills that are sitting in that box? This is a potential nightmare and mess. I really disagree with this practice. Some lawyers do it, some lawyers don't. The other thing, which I think is a bit unsavory, is that when an attorney finds out, they get the phone call from the family and they're like, oh yeah, I have to trust the will, they'll go and they'll file the will that they have in their possession because a will must be filed within 30 days of death of a deceased in the county where the person died. I think that it becomes then a race to the county recorder to see who has the best or the only will. Because if they find the second will, but they don't find the last will, right, then the second will becomes the will.
Right.
I think that's kind of sleazy, to be honest with you.
Yeah, completely. But I don't think that most people are even aware that that could even happen.
Yeah.
Yeah.
It happens.
Yeah. So in my dad's case, because he was a federal employee, what I was told was that the federal courts supersede or are more powerful than the state court, which was handling his divorce with his second wife and had all the paperwork saying that the boy should have gotten money to go to school and just to really live until they were 18. And because he was a federal employee, what we didn't know was that the federal court just gave all of his money benefits of working, decades upon decades. He was 59 when he passed, and he had been working since he got early 20s. Everything went to his third wife, and she did not have to pay the $200,000 owed to the boys to them. So she didn't. Is that really something that happens if you work for the federal government? Then it can supersede, something that happened in a previous divorce and overrule that?
It's kind of a difficult question without seeing sort of the documents, because if, say, your father's benefits were all done by document, what I call will substitutes, so a pension, a profit sharing, a 401k, then they would go directly to the person named as the successor, right?
Oh.
And that has nothing to do with federal law. It's a contract. But, what I find suspicious is, and this is true in Illinois, even if you have a will and you say, create the will and you give everything to, say, the third wife, the children have an interest in that estate. And they have a legitimate argument to receive assets that are in the estate. Now, the problem here is that the federal benefits are, if that was all that was there, then they're gone, right, Julie? Because there's a contract that says this is all going to the third wife. But again, I don't mean to be circular in my logic. I'm just talking out loud. The issue is that there is a I would imagine certified court document of the divorce that says that upon the death of the father, the two children are to be taken care of, and that's a pretty strong argument to take care of those two children. So there's several avenues, without really knowing the case, where this could be challenged. I find that it's a very interesting question you've asked.
It is very interesting, and the problem though is that for middle class, just average middle class people, they don't have $20,000 to spend on a lawyer over 3,
right.
4, 5 years, and that's what it's been. Just so much money to keep the fight going, whereas the person who's kind of taken the money and run has all the money in the world to continue to fight it. So it just feels like in some cases the odds are stacked against you if you don't have this set up right in case of emergency.
Right. And as I said, there probably were several steps that could have been taken to protect the children, particularly the minors. And it's very sad that, again, people don't, they feel like if I go talk to a lawyer, it's going to cost me $500. Well, I don't think that's really, maybe it's true in some cases, but most lawyers, at least that I know, will have a consultation where they will at least look at the documents and then, for no cost, and then maybe say, well, this will take me an hour and it will be, $200, $300. Well, you're talking about $300 of you're trying to protect $200,000 of assets. It's kind of worth it, right?
Absolutely. And Blake and I, when my dad passed away, we didn't know either. We didn't know until we went through this just how important it was. So we decided to do the trust in addition to the will, because God forbid if there was an accident that took both Blake and my life, we would want there to be some speedy quickness in Al going to somebody and nobody in the family, fighting over who gets her, but just that everything's open and closed so that she has the most safety and security that she can in this tragedy, and that she can really go into one home and just stay in one home afterwards.
Right, and and certainly the other thing is certainly situations can change, right? So, you can have backups to backups. I know that sounds crazy talk, but you can certainly do that because situations can change for people. But custody of a minor child is, I think, should have people running to get this resolved and to get a good will prepared by an attorney. You know, there are will documents to be found on the internet. I mean, we all can use Google, but you have to ask yourself: is that did you spend the money to go to law school to understand the intricacies? Because if you didn't, you really shouldn't. And some of them are good, but usually it takes at least it takes me less than 15 minutes to point the firebombs that are existing in this Google search will that you've decided to present me with.
So that leads me to another question. It's one thing to decide upon who is going to take the kids if something happens, but then you go to that person and you ask that person, and sometimes they say no. And this can be a really hard thing to go through as well. Have you seen that? How do you work that through with your clients?
Well, my suggestion is to go, before you do your will, to talk to your family members and, just generally say, we're doing our wills and we want you to be the custodian of our children, and we're going to have, this other person be custodian of the money, so both families will hopefully be involved. Is that something that we could have you do? And you have to have that conversation because you don't. Again, this is back to probate. If that person, can't do it or won't do it, then the court has to decide who will step up and be the custodian of the minor children, and that could be heartbreaking, right?
Oh yeah, absolutely. So, Liz, I think you've given everybody so much valuable information today. Thank you so much for being on the show. If people have questions for you, if they want to reach out to you, if they live in Illinois, how do they reach you?
Well, the best way to reach me is via email, and I have a website, so you can read more about me on my website. So I will give you that address. It starts, of course, with www.lizlaw-chicago.com. That's my website. To reach me via email, that is EJLAW, the number 1, so it's EJLaw1 at AOL.com.
That's perfect, and we'll include all of that in the show notes below. So if you're looking to get a hold of Liz, just look in the show notes, and we will help you with that. Everyone, if you could be an angel and share this with someone in your life who needs this information in order to protect the people that they love, please share it with them, because not everybody knows this information. I know that when it really gets down to talking about a will and trust, it can be uncomfortable, but it's so much more beneficial for us as the adults, as the parents, to be uncomfortable here and now instead of putting our loved ones through an added tragedy of not only losing us at some point, but then also having to go through the tremendous turmoil of figuring all of this out, having to deal with lawyers, going through probate for years on end, and spending more money than you can imagine. If this information and this podcast is something that resonates with you, please leave us a 5-star positive review, and we will enter you into a monthly drawing to win a free session with me. If booking a session with me, a reading to bring through your angels, spirit guides, and loved ones is something that you want to do, it's actually what keeps this podcast going, the money that I use to keep producing these shows. So if you would like to book a session, I offer a 25 or a 55-minute angel reading or Reiki energy healing. You can learn about all of that and book your session right online at www.jancis.com. That's my last name.com, and that website, too, is in the show notes. My friends, thank you so much for being with us here today. I hope that you have a wonderful start to your week. Remember to open up your heart to all of the blessings that your angels, guides, and loved ones are trying to bring into your life. They're talking to me right now, and they're showing me different sessions that I've been through where, like I talked about before, there is free will here on earth, but where they are able to step in and protect you, they do. And they will always continue to do that, but there is only so much that they can do. And what they need you to do is to build your spirit team here on earth, the people who are living, the people who can help you. And having a good lawyer, like Liz said, that you can trust, that you can talk to, that you understand what they're saying and it doesn't sound like foreign and incomprehensible to you, that's what you need. You need somebody who speaks your language, who you know what they're saying in legal terms and you understand it, you get it. Find that person for yourself, even if you have to go to a couple of people, and build your spirit team while you're here on earth. Add a lawyer to that team. My friends, I love you so much. They love you so much. Open your heart to those unexpected blessings. Expect miracles this week. God bless. Thank you so much.